Good afternoon, everybody. This is our Homeline February webinar. I apologize for the slight delay in getting things started. We had some technology issues on our end, but I think everything is sorting itself out now. And so we will go ahead and get started here in just a couple of, well, probably about 30 seconds. I want to let everyone kind of trickle in. Today, we are going to be going through an overview of the proposed tenant landlord law reforms for the 2024 legislative session. So that is going to be our topic. We will again be starting in just a couple of seconds here. I just want to see the participant counter kind of slow its roll, as it were, before we launch into our content here. Thank you very much for joining us today. I do appreciate it. Again, this is our ongoing series of our essentially monthly webinars on various tenant landlord topics. So I think I see, yep, yeah, it looks like we have stalled out a little bit on our people joining, so that's perfect. We'll go ahead and get started here. So again, today we are going to be covering an overview of some of the proposed tenant landlord law reforms that are going up for the 2024 legislative session. That session has started. It started about 2 weeks ago, I believe now. And so we're in the middle of it. The fact that we are in the middle of the legislative session also has meant that our speaker who is on board for speaking today had shifted because the folks who were originally intending to speak, our policy director Michael Dahl and our policy attorney Larry McDonough, both have things to do with committee hearings and things right now. So we instead, thankfully, were able to get our executive director, Eric Hauge, and our Homeline managing attorney for our hotline, Meg Vra, to come and talk to us all about, again, that overview. So if you let me get a couple of housekeeping things out of the way here quick. If you're new here, Homeline, we are a nonprofit that help tenants across the state of Minnesota kind of navigate what their rights are under Minnesota tenant landlord law. We offer free legal, educational, and advocacy services. We've been around since 1992, and we've helped over 315,000 renters in that time. We offer our services in 4 languages: English, Somali, Hmong, and Spanish, as well as an email option. This is our phone number for all of our different lines and how to access our email if that's your preferred method of communication. Couple of things. So the session is being recorded. You should have been warned about that when you first logged on. Our recording will be available on Homeline's website in a few days once we get all loaded up to the cloud. We will have time for questions at the end of this. Some of you were kind enough to pre-submit your questions, which is fabulous. Thank you. But if you do have other questions that come up during the session today, please ask them. We encourage it. We will allow time at the end. Any kind of tenant landlord related questions, we're happy to address them as we are able to, but please ask them through the Q&A function. There's a button that says Q&A that's located at the bottom of your Zoom window. Please use that. You can try, and if you put anything in the chat, I will almost certainly miss it because I will be putting links and other references material in the chat. So I will not be monitoring it for your questions, but I will be monitoring the Q&A for your questions. So please use that. All right, here's our agenda for the day. So we're going to give a quick overview of what this is, some of the background and context, and then some examples of the proposed changes and other proposals that we support. So without further ado, I'm going to actually turn it over then to our executive director, Eric Hauge. Thank you very much, Eric, and please take it away.
Thanks, Rachel, and also thank you, Mike, for joining us for presenting today, and thanks to everybody who's attending and who has been a part of these sessions throughout the past year and beyond. Thanks for joining us today to give us an opportunity to talk through Homeline's legislative agenda for the 2024 legislative session, as well as we're going to be talking through a number of tenant landlord proposals that have been introduced and have had hearings that we support, and just kind of give you a little bit of context and an overview of what's going on in the tenant landlord rental housing space at the Capitol in St. Paul this session. Um, so just to set a little bit of context, most of the laws that impact renters and landlords in the state of Minnesota are state laws. There are federal laws under fair housing rules, as well as certain laws that protect folks and govern and regulate the rules related to certain types of affordable housing, subsidized housing, public housing, etc. But most of the laws that impact renters in the state are state laws and thus go through the state legislative process to get enacted. Um, for a good portion of the laws, there have not been significant changes for many, many years. Last year in 2023, as if you've attended some of our sessions or just read the news or are aware of what happened during the 2023 session. 2023 was a pretty big year, was one of the the most recent legislative years with significant changes for landlords and tenants. And prior to that, 2011 was another really big year that a lot of proposals and new laws were enacted. There have been some sporadic changes in other years since then. Um, Not trying to discount any of the proposals and laws that have been enacted throughout that time, but for the most part, those 2 years were some of the most recent years with significant changes that impacted landlords and tenants in the state. To be honest, Minnesota is really actually still a bit behind what some other states and cities throughout the country have as in the U.S. as far as landlord-tenant protections. Um, and so there are still even with the changes this past year that most of which went into effect on January 1st of 2024. That brought us up to speed on a number of things, such as one of the big ones, which was a pre-eviction notice. Most other states have a law like that. But there are still certain aspects that Minnesota is behind on. All right, next slide, please. So, because there's not been significant overhaul, some of our laws are really significantly outdated and have not kept up with the times and the way that many tenants and landlords do business. A couple examples of things that we want to try to clarify in the law, um, and I'll see if Mike wants to jump in and answer any of these if he wants to. But there are some questions that we get on our tenant hotline. Again, we advise um, thousands of renters throughout the state every year, and many questions are fairly simple and get clear answers, but there's questions like these that where there's not always a clear and understandable answer for tenants or landlords, and we want to make sure that some of these items are clarified. So an example is, can a landlord require a tenant to mow or shovel without paying them a fair price to do the work? Um, and another question is, can a landlord change a lease in the middle of a contract if the lease allows it?
So yeah, I can try to give you the two answers to these two questions. Before I do though, I'll confess that I am the tech issues that made our webinar start a little bit late. And so Rachel was nice enough not to blame me, but it's on me. The good news is I'm in the office today for a webinar. Those of you who are long-term fans of these shows uh, would recognize me from my basement at home, which is where I've done every webinar, I think, since the pandemic began. But today I'm in the office, hence the new tech issues. So there you go. But the questions that Eric just asked are questions that we in fact get on the tenant hotline. So the mowing and the shoveling, especially in a single family home or a duplex, these are really common for landlords to expect a tenant to do this kind of work. And under the law that we currently have, the tenant has a pretty good argument that they shouldn't be required to do this work without being paid. And it should be a fair price and it should be in writing. But the statute that we're relying on here 504B 161 if you want to look it up. Doesn't exactly say that explicitly about shoveling and lawn mowing. It just talks about maintenance. And so some clarification would be really useful on that question where we've gotten mixed results from courts over the years. The next one, can a landlord change a lease in the middle of a contract if the lease allows it? You'd be shocked how many leases say the landlord can make reasonable changes to this contract with reasonable notice or some kind of vague statement like that. And then the landlord will try to change the contract midway through the contract. Is that legal to do so? Almost certainly not if it's challenged in court, depending a little bit on what the topic is. But we see landlords try to do it. We've seen landlords during really bad heating seasons decide, hey, you know what? I know that I'm supposed to pay the gas bill as part of this rental deal, but I'm going to switch that over to the tenant's responsibility in the middle of the contract because I didn't expect the gas bills to be this high. Huge change in the deal between the landlord and the tenant. And if it was the end of the lease, the landlord could make that change. But in the middle of the lease, it's a tougher argument, but the law's not that specific. It doesn't really answer that question as explicitly as we'd like. And so those are the kinds of clarifications we're looking for.
All right, thanks, Mike. So that first step is we want to clarify some of these items. And the next slide is about where we need to modernize the law. So the first bullet here, you all are aware that the internet exists. We're on it right now using this webinar service. But there are aspects of communications between landlords and tenants that have really not been clearly modernized. Text and emails are extremely common written forms of written communication that are used, but it's not always entirely clear if they are allowed in certain legal situations. Another issue is that inflation happens. Many of the penalties that are outlined in Chapter 504B, the chapter of Minnesota law that covers tenant landlord issues, were designed. It was redone in the late 1980s, and many of those penalties were set then in the 1980s. And as a result, inflation means those penalty amounts are significantly behind. One example here is a law that was changed last year, protecting tenants' right to privacy. It used to be set to a $100 civil penalty for a violation, which is effectively such a small penalty. It's almost not worth the time and effort and in some cases harm that can happen, that can come to a tenant if they go ahead and try to enforce their privacy rights. So that was increased last year, but there's many other instances throughout the law that are often ignored. That we hear from our clients on a regular basis, laws that are on the books that have worked for others but are ignored by some landlords because the penalties are effectively meaningless, or in some cases non-existent. There just is not a clear penalty. And really what we need to do is take a look at some of these laws that are unfortunately broken in some cases and assign penalty levels based on the actual harm that might come to a tenant. So a situation like privacy that was amended last year, that can be a very harmful situation when somebody is interrupting you in the privacy of your own home using a key to enter your home. And so there's other situations like that can be extremely harmful that need to be updated. And then lastly, this last bullet is just that we as mentioned before, we are continuing to fall behind what many other states are doing in this area to protect tenants and to better regulate this business relationship. All right, and then the third aspect is equity. We want to make tenant landlord law in Minnesota more equitable. Leases are getting much longer and more complicated. Effectively, what happens here is landlords are in most cases in the situation where they design and draft the lease, or they hire an attorney, or they work with a firm or some other organization that has worked with attorneys to develop a lease. And most of the rules and the regulations of that relationship, that individual tenant landlord relationship, is governed by that lease. And as they continue to get longer and longer and more complicated, there needs to be more regulation and protection of tenants who may not be able to understand the details of what all of those provisions in a 50, 60, 70, 90-page lease. When Homeline started in the early 90s, it was not uncommon for us to see single-page leases. And we still see that occasionally, but it's far more often that we're seeing leases that are at least 50 pages or longer on a very regular basis. All right. And another situation here is that, unfortunately, in many cases, because of the power dynamic in the landlord-tenant situation, in that relationship, there is a power dynamic that does not give tenants a lot of options in terms of being able to negotiate terms of the lease. So there needs to be some intervention on a state level to govern some of these policies that are often ending up in leases. All right, so jump to this next page. This is an example of a 52-page lease that we see very, very frequently. This particular example we got, it's a redacted lease we got from a client in 2023. The lease is prepared by the National Apartment Association, and it is designed for Minnesota, but it has a lot of kind of broader provisions that may or may not impact folks in this state. Did you want to jump in, Mike?
Yeah, quick correction on something you just said. This was not a client of ours that we got this lease from. Yeah, we pulled it from an eviction file from a tenant that we had not advised on purpose. We're attorneys and we can't, we have attorneys on staff, we can't divulge confidential information. And this is simply part of a public record. And that's why we use this one. So I just want to make sure about that.
Thanks, Mike. Apologies for that misstatement. All right. So if you're a tenant and you're in the midst of trying to move into a new place and you're given a 52-page lease to review, it can just be a very daunting task to try to identify exactly what is relevant to you and what might impact you during your tenancy and what is or is not lining up to what the law is, what is or is not unlawful in a landlord-tenant relationship. And so what we did is we went through and assessed this particular lease to try to identify how and where there were terms that might directly or indirectly impact tenants, and effectively tried to a certain extent highlight the portions that are either specifically friendly to landlords and items that are specifically friendly to tenants. And so the next slide gives you an overview. The reddish or pinkish color are provisions that are, for the most part, beneficial to landlords, and the green provisions are those that are more beneficial to tenants. It's difficult to see. It's a 52-page lease. We also have a physical copy. This one has more colors on it. We color coded this copy to also identify neutral provisions in yellow and blue provisions that are just a restatement of Minnesota law. But the important thing to note in this 52-page lease is that 52% of the lease is marked in red or light red that effectively protects landlords' interest, and about 6% is more tenant friendly or protects tenants' interests. And again, as I mentioned, other provisions are either neutral or they reiterate existing state or in some cases federal law. If you were to just add those reiterations of existing law to the tenant-friendly tenant interest, it would be 15% total. So in reality, this is what happens is that leases have gotten longer to primarily protect the interest of landlords, and in some cases to the detriment of tenants. Mike, did you have anything else you want to share about this lease?
Right. So I assume that not everybody has watched every one of our webinars, but something that I have talked about over the years on these sessions is that for a lease to really function, you need four, what I refer to as pillars. You need 4 pillars of a lease. And they're pretty simple. You could guess what they are, but here they are. You need the parties that are involved. Who's the landlord? Who's the tenant? You need the property, so the address that we're talking about. You need the duration. Is it month to month? Is it 1 year? And you need the price. How much does it cost to live here? Those are the four key elements of a lease. And that's why a lease in 1992 when Homeline started would have been one page or maybe two sides of one page, most commonly back then. And as Eric has just said, these leases have grown. And honestly, they've accelerated in their growth in the last 15 years. I would say, having watched these leases since 1996 when I started at Homeline. And Eric is right. Most of the lease is written to protect a landlord, which is not a shock. It's written by landlords for landlords with counsel. Maybe they just downloaded something online. But tenants never present their favorite lease and say, hey, landlord, let's use this lease. I like it better. Landlords just don't accept that. They provide the lease. And so that's why there's very little bargaining power for tenants, especially if the market's tight.
All right. Next slide, please. And I think I mentioned some of this already. Yeah, as I mentioned, it was common for us to see one-page leases originally, and tenants have effectively been living with many more increased rules and regulations. In addition to what's actually in a lease, we also see handbooks or guides that are additional requirements or rules. And so it's really important to take a look at that and just reflect on the fact that, there were some significant changes to Minnesota tenant landlord law last year, much of which went into effect in January of this year. And in reality, what that was it was a rebalancing of that relationship, because so many of these leases have increased rules and regulations that are directly targeting the behavior and the activities of tenants in that relationship. And so really as this bullet point says, the only checks are to use state or local law to correct this imbalance of power. We have seen a lot of cities in recent years, in the past 5 to 10 years, increasing their their power and their ordinances and their role in these relationships. More cities, particularly in the metro area, adopting rental licensing, rental inspections. But in addition to the kind of identifying and focusing on health and safety issues, going beyond that, and adopting, prior to the state adopting the pre-eviction notice, there were several cities that adopted their own local ordinance. And there's a variety of other examples. So, leases, and again, these are one-time changes that happen at the state level. There was a lot of media attention. We did a series of webinars all throughout the over the half of last year. We did a monthly webinar leading up to the new law changes this year, because there were significant changes. But at the same time, when you think about it, many of our clients, many renters throughout the state, sometimes see rules and regulations that change yearly, or in some cases even monthly, with month-to-month leases where landlords are able to change the terms of the lease. So we also want to create some stability here, so that folks know what the rules are. Okay, all right, next slide. So there are we have a short legislative session this year. It is the second half of the legislative biennium. Last year was the longer session where there was more time to look into some of these policy issues. This year it's quite a bit shorter, and the legislature also adopts their own committee deadlines, by which when committees are supposed to take action on bills, policy bills that don't have to do with money, which most of these tenant landlord bills are policy related. And so the first deadline, or the first and this year really only deadline for policy bills, is March 22nd. So that's just about a month away, that pretty much any sort of policy related bill that might impact housing, tenant landlord law, has to get through both the relevant committees in both the House and the Senate by March 22nd. Most landlord-tenant laws, policy bills have to go through about 4 committees, 2 in each body. There's in both bodies, there's housing and homelessness related committees. And so they have to pass the housing committee in both the House and the Senate. And then both the House and the Senate also have civil law or judiciary related committees, which these policy bills often have to go through both of those committees as well. So we have a very little amount of time and a lot of content to try to modernize Minnesota tenant rights. Mike is going to go through the details of the bill that Homeline has had a hand in preparing to try to clarify, modernize, and make more equitable Minnesota's tenant landlord laws. And while it's not entirely inclusive of every good idea and policy idea that would be helpful in that relationship, in the tenant landlord business relationship, it is our attempt at trying to, again, modernize and clarify and make those laws more equitable in that relationship. We're also going to talk more towards the end about a number of other policy related bills that impact renters. There are a lot that have been introduced this biennium, both last year in 2023 and a ton that have been introduced just in the past, just since session started a couple 2 weeks ago or so. We're not going to go through all of them, but we'll mention some of them that have some motion and are having committee hearings. And obviously Homeline supports our main modernization bill, and we also support a number of the other tenant landlord policies. Okay, so the next slide is just so I'm filling the role of Michael Dahl, our public policy director today, who's at the Capitol for a committee hearing. There's his email address. If you are interested in either organizationally endorsing this modernization bill, those are the Senate file and House file numbers on your screen there. And Rachel just threw the link to the House file in the chat. Please email Michael to endorse. As an individual, you can also, and we can throw these links in the chat, but you can look up who your legislators are using the Minnesota Legislative District Finder. And regardless of who your legislators are, which committees they're on, they may or may not be on the relevant housing or civil law judiciary committees. It's always a helpful thing if you support these policies or any other tenant landlord related tenant protection bill. You can look up your legislators, get their emails and their phone numbers, and call them to tell them you support, and you can mention the House or the Senate file number and ask them to do what they can to support that bill or those bills. So we'll throw those links in the chat. Oh, Rachel's ahead of me. There's the who represents me item. So there's already hearings coming up very soon. And so there's a lot of activity going on that'll be happening just again between now and March 22nd, which is that first deadline. The other place I'll just mention that you can get updates, that although they're not as frequent, given that committee deadline is coming up so quick. But if you want to keep informed, you should sign up for our newsletter. Hopefully you're already signed up if you've been on previous webinars, but we do provide some public policy state legislative updates in our newsletter as well. So we'll throw a link in the chat for that as well. And with that, I think my portion is done for now, and I'll pass it over to Mike, who's going to go into more detail about that bill, Senate File 3492, House File 3591. Thanks, Mike.
Sure.
Mike, your technology issues have creeped over the hall to me, and I am having issues getting some stuff copy and pasted into the chat. So I will continue to forward the slides, but I'm working on the links that Eric was talking about. And if for some reason I can't forward the slides, I'll let you know, and we'll have to figure that out. So
all right, well, let's see if you can
heads up.
advance this first slide and see what happens. Hey,
No, I cannot. All
wrong
right.
way.
Stand by.
Standing by.
While Rachel's working on that, I'll just remind folks, again, if you do have questions, use the Q&A. We'll get to them at the end. We can't promise we can answer all of them. But we'll try to get to them. And oh, it looks like Rachel's to the slide now, so I'll be quiet.
We'll
Okay.
see if we can actually continue on with that.
So I am not talking about the entire bill today. The entire bill was 74 pages, I believe, of proposed changes to landlord-tenant law in Minnesota, which was sort of the charge that Homeline took on, was to reimagine what landlord-tenant law could look like in Minnesota. And so we looked at each portion of 504B, the key chapter in Minnesota landlord-tenant law, and thought, what is out of date? What should be replaced? What should be added? What should be removed? And passed it along to some legislators, and they've made some changes to it. I mean, we can just make suggestions. The legislators are the ones that actually carry bills forward. And what remains is what we're going to talk about today, at least some of the things that we're going to talk about today. It's not a complete list because that would take us a lot longer to go through the entire list. But we're going to talk about some of the key stuff. So here are the highlights of what we're going to talk about for the next roughly hour or so. First up, strengthening enforcement or creating enforcement of bills. Habitability updates. Other than the last 20 months or so in Homeline's existence, the most common reason why tenants have called our tenant hotline, where last year we took about 20,000 calls, is the landlord isn't fixing something. So it's a very common issue, habitability, that we and our clients are trying to figure out the answers to. Next up, a landlord's duty to mitigate damages if a tenant breaks their lease early. Expanded retaliation defense, prohibited pre-lease deposits. So pre-lease deposits that are allowable right now, prohibiting those. And perhaps, well, one of the most substantial changes we're proposing is banning application fees being passed on to tenants when it comes to applying for rental housing. Those are the headlines about what we're going to talk about for the next hour. So let's go ahead and dive in. We'll start with habitability. I'm sorry, with enforcement, my mistake, with enforcement updates. All right, so what we're talking about here is a couple of different things. First of all, expanding a tenant's ability to enforce their rights, whether it's they have an avenue to get into court on a certain topic that right now would be very difficult to do. Most commonly being solved by allowing a tenant to file a rent escrow. A rent escrow is a court action a tenant can file right now. However, the general vibe of rent escrows is it's about repair issues. This is trying to expand it to include more issues and give a tenant easier access to court to try to solve a problem. Rent escrows are set statutorily price-wise at the same price as small claims court, around $70, $75 for somebody to apply. That fee, of course, is waived if a tenant's income, or anybody trying to file a court case, their income is low enough to qualify for an income-based fee waiver. We want to add language that will give heightened penalties, modernizing things, making it meaningful. Having a statute that doesn't have any teeth or very weak teeth means that landlords might just disregard that statute. And so this is trying to punch up the enforcement mechanism, whether it's a fine or something like that, that is necessary to make these laws that we have on the books actually mean something. And again, increasing penalties to the point where landlords will think twice about whether or not it makes sense for them to ignore a statute, which they might be doing. Okay, let's go ahead and move on to the next slide. And we're going to do our first example of an enforcement example. So what we're looking at here is, first of all, the current version of the current law is the non-underlined part. When you're looking at statutory interpretations, usually when you see something underlined, that means it's a new part of a statute that's being proposed. If you see a strike through, that means it's something that's being proposed to be deleted. So we have this current statute, which has been around for 10, 12 years, 504B 118. Again, 504B is the chapter of Minnesota law where we find most landlord-tenant statutes. And this statute says that a landlord basically has to give a receipt to a tenant paying with cash or a money order. If it's in person, the receipt's supposed to be given immediately to the tenant. If it's not in person, the landlord's supposed to give it to them within 3 days. So this law as it sits currently has no real teeth. It just doesn't. I mean, a landlord is supposed to do something, but if they don't do it, what's the penalty against them? It's not stated clearly in this statute. And so the proposal is, well, okay, we have some boilerplate language that we've suggested throughout the 504B. And I'll just read that part. Any attempted waiver of this section, which means 504B 118, by a landlord and tenant, by contract or otherwise, so no matter what the lease says, shall be void and unenforceable. So this happens a lot in landlord-tenant law, not just in Minnesota, everywhere through the country, where a lease will be overridden by the law, or the law will supersede the lease. Why is that? Why are we interfering with a contract? Why is a statute saying we're not going to allow two adults to contract how they wish to? Well, again, this goes back to a couple key points. Landlords always write the leases. Tenants don't have a lot of ability to negotiate that. And, you know, this is pretty important stuff. This is where people live. So we're going to have some regulation on this. I mean, it's not unparalleled in other parts of our society. Go try to buy a new car from a car dealer and see if they'll knock $500 off if they'll take the seat belts out of that new car. You just can't do it. You can't contract that way because we've decided societally, nope, we're going to require seat belts. Okay. And that same kind of guardrail line of thought for contracts has worked for landlord-tenant law since the 70s, the 80s. Again, not just in states where Democrats control the legislature and the governor's chair, but every state in the country, we have laws that try to regulate landlord-tenant contracts. And so that's what this is trying to do, is trying to waive, a landlord can't waive this, this rule by putting it in the lease. So we go on to the rest of the part, and it talks about some damages. Tenant can recover actual and consequential damages. So what that means is, well, it's actually treble actual and consequential damages, which means 3 times whatever the tenant's expenses might be if this happens. Let's say the money order gets lost and the tenant has to reorder a money order and they have to pay something for that. Maybe it would be 3 times the cost of that, or $250, whichever's higher, plus reasonable attorney's fees. So the $250, I think, is the lowest proposed penalty that we have suggested. I think we have 500 and 1,000. There might be 1 or 2 at 750 as well. But we tried to sort of rank them with the severity of the issue, the importance of the issue, the how seriously we think the legislature should treat this issue. And so that was our suggestion, was 250 on this issue. But it's an example of an enforcement necessary because as the law sits currently, again, the non-underlined portion, there's no real enforcement mechanism built into that statute. Okay, let's go on to another example here. We're going to talk about habitability. All right, so when we're talking about habitability, there's a couple places that one could look in the 504B chapter, but where most people would start would be where we find the covenants of habitability, which is found in 504B.161. Covenants of habitability are basically, just to sort of summarize what we have there, it's fit for the use intended. The place has to be fit for the use intended. The place has to be in reasonable repair and up to safety and health codes. There's also a couple other things, one about weatherproofing, and the latest version, which was added just this January, that the landlord has to, if they're responsible for the heat, they have to make sure it's at least 68 degrees in the rental unit during the winter. That's where we find these rules, is in 504B.161. However, we'd like to see some other inclusions to be really clear about what the law is trying to do. So the landlord is responsible for providing the property as advertised and promised. Sounds basic, but it's the kind of thing that if you don't have it explicitly stated, it's hard to enforce sometimes. Each of the covenants applies to all common areas. The way that it was originally drafted, it doesn't really appear that that's true, but that was probably the intention. So that's really trying to update / clarify something. Adding the list from the ETRA thing to the covenants, adding federal laws and rental licensing ordinances, allowing a personal injury claim from a tenant against a landlord to be viable. Personal injury claims for tenants against landlords are a really high mountain for a tenant to try to climb. And most personal injury attorneys wouldn't touch one of those cases, even with really great facts from a personal injury standpoint. Landlords have a lot of immunity built into case law that's been developed over decades here in Minnesota. a statute of limitations, and add an enforcement through to TRAs, the tenant remedies actions, rent escrows, ETRAs, the emergency cases, eviction actions, and other civil cases. Let's go ahead and go to the next slide, a little bit more about habitability there. All right, so we've got a couple examples here of some statutes. Again, and the first one, 504B131, is what we generally call or refer to as a constructive eviction. It's not a phrase that you'll find in the statute itself, but it is reflected in case law in Minnesota. And if you Google something like this enough, you'll find constructive eviction conversations generally when it comes to this concept. What we're talking about here is if the place gets destroyed, if the rental unit gets destroyed or it's unlivable because of damages, repairs, nothing caused by the tenant, that the tenant is allowed to simply leave the contract. They can move out, get all their stuff out, whatever they can, give the landlord a piece of paper and the keys saying, I'm done, I'm not in possession anymore. And because it's not livable, I don't owe anymore either. Any attempt at trying to waive this wouldn't work currently, but we're trying to make this really clear. And if a landlord tries to dodge their responsibilities of letting a tenant out of the lease here and maybe sues the tenant later on, tenant doesn't really have anything they can use on the offensive. The landlord might sue them for unpaid rent, which can be a burden for a tenant to try to push back against in court and assert their defense. And so we've proposed a serious defense that a tenant would have, that if the landlord decides to go after a tenant in a situation like that, the tenant should have the ability to counterclaim against the landlord for something. Right now, they really don't. All they can really do is defend that case saying, no, I don't owe this. I don't think that's fair. This is giving the tenant a $1,000 penalty potentially plus attorney's fees, or triple the damages that they've incurred based on this as well. Again, we look at 504B.204, where here we see one of those strike throughs that I talked about, where we're suggesting that part of the statute be deleted and a new version be put in. And this is when we have a condemned rental premises, which is almost always by a city entity, a city inspector's office or something like that, would be involved generally in these sorts of things. Again, this would give the tenant more that they could seek. That we're trying to modernize the penalty when it comes to this one, which I don't know the last time that one was actually changed from 250. In all honesty, it's hard to know that answer to things if it was done before 1998, because all of the statutes in Minnesota were recodified then. So if you do research, you have to find a really old version of the law to figure out when this was last modified. But it was, I think it was prior to 1998 was the last change to this one. Okay, let's keep going here. And we are up to mitigation. So what we're talking about here is the tenant leaves in the middle of their contract, a break lease kind of situation. We keep track of why tenants call our office. We have about 70 categories, I think, that we mark down when they call, and we keep track of it in a database. And this is always in the top 10. The tenant wants to break a lease. Sometimes it's as high as the top 5, where a tenant will want to get out of the lease. Pretty common call that we get. I want to get out of my lease. When am I allowed to do it? How can I do it? There are a couple situations where a tenant can break their lease unilaterally, whether the landlord wants it or not. If you're in the military and you get called up or transferred, if you die, pass away, then you get out of your lease. If you have a medical condition, disability, and you need to move to a medical facility, you can get out of your lease. Domestic abuse or fear of domestic violence, or any kind of violence really, where you need to get something like a restraining order, might get you out of a lease. So these are the unilateral versions where a tenant might be able to get out of a lease. But what if a tenant just wants to leave, but they don't have one of those qualifying, I get out of my lease without penalty options available to them? Well, again, a tenant can always just go. There's no law that says that a tenant has to keep possession physically of a place. I mean, movie stars or, famous people like to have apartments in lots of different cities, and there's no law against that. You have no obligation to physically occupy a space when you decide to rent a rental unit. But you can go. So the tenant would simply leave if they wanted to get out of their lease. And under current Minnesota law, which has been developed since about the 1940s, and some of it's commercial, some of it's residential, but the net effect of this is that in Minnesota, a landlord doesn't really have a duty to even try to find a new renter. So if a tenant leaves, let's just use January 1 to December 31, the tenant leaves on March 1st and there's 9 months left on the lease, the landlord has no obligation to even try to find a new tenant in that situation. Now, most landlords do try to find a new tenant because it's the best business move for them, right? I mean, what are the landlord's options in that situation? They can chase this tenant who left for money, maybe some other state, who knows? Maybe the landlord will ultimately get money from them, maybe they won't. But most landlords, if you had to make them place a bet, they would say, I'm never going to see another penny of that money. I'd rather get somebody new in here that can start paying rent on the first of each month instead of chasing somebody for 9 months of rent. So most landlords try really hard to re-rent, but some don't. Some say, I'm not even going to try. I like the idea of collecting rent from you, even though you're not here. There's no wear and tear in my place. So this is kind of ideal for me. You're locked into the contract and I'm going to make you pay. So you can make all kinds of arguments about the fairness of this, but here's what I can say about it, which is 43 states disagree with Minnesota. So almost every state says, hey, landlord, at least go try. At least go try to find a new tenant. So that's really what this law is trying to do, is trying to make things more equitable. And with the giant consensus in the United States that this should be done, I'm not even sure how much landlord groups would fight this one if they thought about it. But I'm guessing we'll still see pushback on this because we seem to see it on virtually everything that's proposed at the legislative level. But we'll find out. Anyhow, that's mitigation. Next up is retaliation. There we go. Wow, that's a lot of ink on the screen. So why am I talking about retaliation? We already have at least 2 retaliation statutes in Minnesota on landlord-tenant law. Let me paint the picture of why it's something of a useless right today, retaliation for tenants, at least largely. So the most common form of retaliation that a landlord would engage in is probably the safest one for them to do, which is to not renew a lease. Let's say a tenant has a 12-month lease. Again, we'll go from January 1 through December 31. The landlord hasn't liked the tenant. Let's just assume the tenant was from the landlord's perspective, a complainer. They always were talking about something not working in their place, or the hallway, or the security door, or something like that, that they just would persist with the landlord to the point where the landlord just doesn't want to do business with this person anymore. They want them gone. And the landlord thinks, well, look, I signed a 1-year contract with this person. I didn't sign a lifetime deal with this person. So when the year's up, I just don't want to do another year with them. So I'm going to non-renew the tenant. Let's say the tenant even took it a little further. They sent a 14-day letter. They called a city inspector out about some repair issues. Under the current law, if a tenant were to call us in November 10th, saying, hey, my landlord gave me a notice on October 31 to leave by December 31, saying my lease was over, they're not renewing it. And I went to ask them why, and they said, we're not going to tell you. We're not going to tell you why we didn't renew your lease, and we don't have to. The law doesn't make us do that. Okay. So what's the tenant's option at that point? How do they assert a retaliation defense? Well, they could try to do a rent escrow. Again, a court case they could go file. The problems with that are multiple. First, there's limited time. The tenant could get into court within about a month if they went as quickly as they could. So maybe that would get them into court on December 10th. But what if the tenant didn't decide to try to fight against this until later in November? They might run out of time. The other option, or the other problem with rent escrows is, again, rent escrows usually are about repairs. And so courts are reluctant to do much of anything with rent escrows beyond repairs in general. It's not always true, but that's kind of a general feeling that courts seem to share with the world when it comes to rent escrows. Isn't this just about repairs? And so it's not necessarily easy to get retaliation in there, even though I think it fits. There you go. So the tenant's best way to use retaliation is as a defense. So how does that work? Well, again, the landlord told the tenant to leave by December 31, and the tenant would refuse to go. They would hold over is the legal term for it. So on January 1, the landlord would go file an eviction against the tenant in court for holding over. Okay, so the tenant would then have the right to stand up in court a couple weeks later and say, Judge, they gave me a notice to vacate or a non-renewal notice. That's true. It was properly timed. It was in writing, but it was in retaliation for me calling the city inspector, giving a 14-day letter to repair something or something like that. All right, and then the tenant would have a chance to assert that defense in court. Well, what's wrong with that? Well, the tenant invited an eviction to be filed against them. That's what they basically did in order to assert this retaliation defense. Problem with that is there's an eviction on their record right away, immediately. It's publicly available information. And as we all know, the minute an eviction is on somebody's record, good luck trying to find another place, certainly in a metro area, with a very recent eviction on your rental history. It's going to make it very difficult, perhaps impossible, to get another rental, at least in the near future. So it's a huge gamble for a tenant to try a retaliation defense to an eviction. And so, among other things, one of the things we're trying to get done is make it very clear that a tenant could use a rent escrow for a retaliatory, in their mind, non-renewal or giant rent increase or something like that. It would also do some other things like extending the presumption of the retaliation trigger time frame. So right now, if a tenant has asserted their rights as a tenant, if the landlord retaliates against them within 90 days, the burden is on the landlord to show that they didn't do it for a retaliatory reason. That's a summary of the rules, but that's pretty much accurate. This would extend that to 1 year. I mean, I've always thought that the most retaliatory conduct by a landlord would be on day 91. Because they'd realize when the 91st day is, and that's when they'd take the action. If I were a judge looking at that, it would almost be a telegraph that the landlord was in fact aware of the retaliation rules and tried to figure out a way around them. Gives the tenants the right to demand a written explanation for the non-renewal. Without any hesitation in my mind, the angriest tenants that Homeline sees or talks to on the phone when they call us are tenants who had non-renewal. They asked the landlord why, and the landlord said, I don't have to tell you why. I'm not going to tell you. Those tenants are furious, livid. Their home that they've been paying rent for a year, 2, 3, 4, 5 years, told suddenly, from their perspective, really flippantly, we don't have to tell you why we're going to, non-renew your lease or why we've already non-renewed your lease. The truth is most landlords, well, I think probably closer to all landlords, don't non-renew a lease without a really good reason from the landlord's perspective. Now, they might not want to share that reason with the tenant because maybe it's not necessarily the best reason, but landlords are not in the turnover business. Landlords they don't like turnover. They lose money on turnover. So landlords aren't just kicking people out just to do it. And this is going to make it harder for a landlord to do that without justification. It's close to a just cause concept, but that's a different notion. It goes quite a bit deeper, and it's something that Homeline didn't propose, but was proposed by another legislator on their own. But we are in support of that as well. I'm just looking at the time. Let's go on to the next topic. So let's talk about pre-lease deposits and application fees. So these are sort of related because they're both prior to the lease being signed. Both pre-lease deposit fees and application fees serve as a financial barrier to people trying to qualify for housing. Application fees, let's talk about that first. How much is that? Well, and what we're talking about here is the background check, the tenant screening that landlords simply pass through to tenants. They say, tenant, if you want the place, you got to apply, and here's what it's going to cost you to apply. We're usually talking somewhere between $25 to $75 per adult. We've heard as high as $100, $125 even per adult to apply for a place. But 25 to 75 seems to be the zone where most landlords are charging. So there's that the tenant will have to pay to try to qualify for the housing. A pre-lease deposit is different, and it's a lot more money usually too. It's somewhere between $250 and $500 typically. Here, what the tenant is doing is they're putting money down to hold the place while their application is being considered. The application fee itself is usually pretty much the same thing the landlord pays to the screening company. But the deposit is to make sure that the tenant understands that they're sort of on the hook for the place if they're approved. The tenant's kind of locked in one direction while the landlord is not locked in. These have been around a long time. They were regulated in the 1990s, pre-lease deposits were. And then they kind of disappeared until about 12, 15 years ago. And then they started to resurface. Landlords have decided to start to use these again. And so let's get on to the proposals. We'll talk about the pre-lease deposit first. So again, the landlord will charge this amount, somewhere between $250 and $500 for a pre-lease deposit. The current law, which I guess we don't have the statute up here, but this is 175, 504B.175, says that the landlord has to have really specific language in something in writing saying what's going to happen to that deposit if the tenant is approved or not approved. For whatever reason, which has always remained beyond me, a lot of landlords, and by a lot, I'm saying 20 to 30% is my best guess, of landlords, and these are some of the sophisticated landlords. These aren't the mom and pop amateur landlords who don't really know what they're doing. Some sophisticated landlords don't track the necessary language in this statute, which isn't that hard to track. The key language that they leave out is that if the tenant is denied, that the money has to be returned within 7 days, which is what the law explicitly says. Anyhow, landlords don't comply with that part of it for whatever reason, and end up taking these pre-lease deposits. Again, $250 to $500. It's a lot of money that the tenant has to tie up to try to qualify for a place. The proposal that we put in place would simply ban the requirement that landlords could say, hey, I need you to put down a pre-lease deposit in order to have a shot at this place. Moving on, we're supporting the concept of banning application fees as well. This is a there's no real way to minimize the potential course change in landlord-tenant law. This is a big deal to say we shouldn't have application fees. Now, we wouldn't be the only state to consider this sort of thing. So as you can see on the screen, there's some states that prohibit pre-lease deposits already. There's some states that prohibit application fees already. Again, we're talking about $30 to $50, $25 to $75 if you want to expand it out. Maybe it goes even higher. We talk to people on the phone, clients who are trying to qualify for housing that will pay 3, 5, 8 application fees. We're talking hundreds of dollars. Again, if there's 2 people in the family that are adults that are applying together, double that amount. And they keep getting turned down. Why are they getting turned down? Well, under the current law, the application fee statutes that we have in Minnesota, the landlord has an obligation to divulge their criteria, but it doesn't say how specific that criteria has to be. So some landlords are really transparent about this. They'll say something like, you know what, we're going to check your credit. You have to have a credit score of 575 or you don't qualify. Now, the tenant might not know their credit. Maybe they do, but that is a very knowable thing, 575 for a credit score. So if a tenant wants to find out their credit score, they could see, am I going to have a shot at qualifying for this place or not? Now, the landlord could do that. They could say credit 575, or this is something other landlords do. They'll simply say our criteria is we look at your credit, your criminal record, your rental history, and we look at your income. And then we decide if you qualify based on those 4 factors. Oh, okay, what does my credit score need to be? We're not going to tell you that. We're not going to tell you the credit score you need to qualify. They don't give that kind of specific criteria. Instead, they give the sort of the overview criteria that we look at stuff, but we're not going to tell you the specific stuff that gets you a no from us. And my hunch is that if application fees were banned, landlords would still be doing tenant screening. They'd still be paying these screening companies for application fees, but they would be much more transparent on their criteria, because a landlord would have a lot to lose by sending in multiple applications and having them all get turned down if they have to pay the fee. Right now, landlords simply pass this fee through. Now, this isn't always true. There are some landlords with some types of public subsidies that don't or can't charge application fees. There are some landlords that don't charge application fees now, that they incur that cost on their own. And I guess there is a legal benefit to that from a landlord's perspective, which is they don't have to divulge their criteria. If the landlord charges an application fee under Minnesota law currently, they have to disclose what their criteria is. But again, it doesn't say the specificity that criteria has to be divulged. So landlords don't say credit score 575. They simply say, I'm going to look at your credit. That's just one example of how they try to think this through. Go ahead and go to the next slide, a little bit more about application fees. So this report that we're seeing a quick summary of was put together by Zillow, got a lot of press last spring. And basically what it found out is that that certain groups were being charged application fees more than others. So if you're Black, you're going to probably pay an application fee 89% of the time. If you're white, it's 82% of the time. It's, I think, naive to assume that racial discrimination or a lot of other types of discrimination don't happen in rental housing. That's why we have the laws. But this kind of blatant, but sort of, it's a lower penalty type of discrimination, but it's still a penalty, right? I mean, if 89% of people that are Black are paying an application fee and only 82% of white people are, that's a 7% difference. And that's hard. It's impossible to justify that that's what's going on, but that's what's being reported to the agency that was doing the survey, which was a pretty neutral place, which actually sides more with landlords than with tenants. And the charges for application fees were seen as higher. So application fees, when a landlord hires a screening company, they usually have options. There's sort of a silver package and the gold package and then the platinum package. The platinum package is going to cost the most and it's going to do the most thorough search. And so landlords can sometimes select which one they want to use. And the other thing about application fees is when you look at any kind of taxes that are ever proposed, a sales tax, an income tax, a property tax, one of the things that you'll hear kicked around, a phrase that you'll hear kicked around a lot is, this is a regressive tax. What does that mean? Well, that means that people that have a lot of money are hurt less by a regressive tax than people with very little money. And application fees are exactly like that. They're completely regressive. So let me tell you what I mean by that. If I'm applying for a place that's $800 a month, me and my own, somewhere in the metro area for a small studio apartment, just me, one person renting, $800 a month. I'm going to pay $50 for an application fee, okay, as one adult. If I want to rent a mansion on Lake Minnetonka that has views in every direction, it's out on one of those peninsulas, right? And it's $7,500 a month. I'm going to pay $50 for an application fee. Now, obviously, if I'm renting that place in Lake Minnetonka, I can afford a lot more. I have a lot more money, income, access, but I'm still paying the same application fee that somebody was looking for a studio apartment for $800 a month. So this is a really regressive fee that tenants absorb. And many low-income tenants absorb this multiple times trying to qualify for housing because the criteria are so uselessly vague that they don't mean anything. So the proposal that we put forward and that we support strongly is the concept of simply banning fees outright. Okay, I'm going to have a sip of something. I think Eric's going to talk a little bit about some new other legislation that has been proposed by other sources.
All right, we're giving Mike a well-deserved break to take a breather. And I'm gonna just really scoot through this. There's a lot on the screen there, and there could be more. But we're just gonna highlight a few bills that either came up last year or have recently been introduced this year, related to tenant landlord legislation. And first on the list is source of income protections. Now there was a bill last year on this, and there's a revised bill that was just recently introduced. Source of income protections is a is a policy that effectively creates a category of non-discrimination or discrimination that would prohibit the discrimination against renters who intend to use some other form of income through a rental subsidy, Section 8 voucher, some other rental vouchers, such as some of the new proposals at the legislature to enact a state rental voucher, and would make that discriminatory action to prohibit or deny someone on the basis of how they're going to pay for their rent, such as using a voucher or rental voucher. The policy last year was included in some omnibus bills related to housing and civil law, and in the end was negotiated out of the final package that was passed as law and provided all the new laws that mostly went into effect on January 1st. This is a big issue in Minnesota. The city of Minneapolis adopted a local protection in 2017 or 2018. I think I'm getting those dates right. And it has been challenged and been up to the Minnesota Supreme Court and back. And the city is now enforcing that protection. And so the idea is that it should be expanded to protect renters throughout the state. And it was highlighted at a rally at the Capitol yesterday as a key issue to get enacted to help support other housing efforts, such as the Bring It Home campaign, which would create a new rental voucher system in the state. Right to organize is a critically important protection. Renters in certain types of subsidized housing have protections against retaliation and other types of harassment when they are working to organize with their neighbors to address housing issues, conditions, habitability, mismanagement, those types of issues. Or in the case of subsidized housing on a federal level, to work together to preserve and maintain the housing affordability of their rental units. So this bill would work to expand that to more renters, to market rate renters and other renters throughout the state. And we see that as a really important policy to give tenants the ability to take collective action to improve their homes, which they're already doing, but sometimes face hurdles doing that, such as harassment or intervention when they're trying to door knock or flyer or use common areas for meetings, those types of things. Homeline is also, I'll talk about one more here, Just Cause. This bill, I think, was introduced last year, or maybe this might be the newer bill, sorry. Just Cause is a protection against informal or extrajudicial displacement. So Minnesota is a no cause termination state. You can either the tenant or the landlord can choose to end a lease at the end of their term, whether it's a year or a month-to-month tenancy, as long as there's proper notice given. No reason or cause is needed to simply end a lease at the end of its term. Unfortunately, that is sometimes from the experience of our clients, often hear from renters who are on extremely fragile leases, month-to-month tenancies with maybe a 30-day notice, who are given only that amount of time for a lease termination and given no reason for why that's happening. So this is an effort to maintain renter stability throughout the state. Renters in certain types of subsidized housing have this protection, and we see it as another critically important protection for renters. Renters in the city of Brooklyn Center have a similar protection, a local protection that was enacted in the past couple of years, and it's benefited renters in that city. There's other cities that are looking at adopting something like that. So again, this is another one similar to source of income protections where we see that it would be really instrumental and helpful to have a standardized statewide approach, one policy that regulates all tenants and landlords and housing throughout the state. Those three: source of income, right to organize, just cause. Homeline is a part of coalitions that are working to get those bills passed. There's been hearings already on right to organize, I think last week and maybe again this week. And so those are some bills, tenant landlord bills, that are sort of on the docket for this year. A number of others that have been introduced and are either coming up for hearings or there's an expectation that they'll be heard in housing or civil law judiciary committees. House File 3843 that would regulate the use of ITIN, or individual tax identification numbers, for folks that perhaps don't have a social security number in the tenant screening and application process. The next bill, House File 3961, tenant remedies regarding new construction delays, is coming from some issues at the U of M campus, where an apartment was pre-leased to, that was being built, was pre-leased to students and was not ready because of new construction delays. So that regulates that area. Right to repair and deduct. This is a law, so House File 1094, that's a law that renters in other states have for certain types of repairs. Would give renters the right to go ahead and pay for a repair and deduct it from their monthly rent amount. The next one, Fair Chance Access to Housing Act, Senate File 4015. There's not a House companion yet, I don't believe. Would regulate the tenant screening process, and specifically around criminal backgrounds. There's a lot more detail in all of these. We're just really trying to run through a number of these, and you can look them up yourself if you have more questions. There have been, local efforts to regulate tenant screening processes in Minneapolis and St. Paul that have proven to be helpful to provide better housing access to renters who may not have the perfect records, and this is an effort to increase access to rental housing. House Bill 3845 is kind of, I believe, somewhat of a follow-up on policies enacted in 2023 regarding late fees, as well as the process of the summons and complaint in the process of serving eviction summons and complaint in an eviction action. These next two, House File 3917 and House File 3810, are related to the ability to contact emergency services. There are sometimes penalties that are given to tenants when they reach out for emergency services. So that would clarify an existing statute on that and make it more clear and comprehensive in terms of protecting tenants when they reach out to contact emergency services. And then the next one governs evictions and expansion of expungements related to evictions when a victim of a crime is terminating their lease. There was also a bill that's been worked on for a number of years around disclosures, testing of radon in rental housing, and disclosures to the tenant regarding that. That's Senate File 3807. So those are just a handful of bills, other bills that Homeline supports, and that we're a member of coalitions for some of these that to work on advocating for them. If you have questions about these, you can reach out to Homeline. I think the next slide maybe has Michael's contact information, or no, it's the question, sorry. But there's actually hearings on a number of these bills in both this week. I think yesterday there were hearings, today and tomorrow there are hearings on a number of bills in both the Senate Housing Committee and the House Housing Committee. I'm going to throw in the chat. You can just see now I've lost where I was looking here. I apologize. Anyway, So for example, here is the list of what is being heard, I believe today in the House Housing Committee, which includes some of these bills.
Yep. Awesome. Thank you for that, Eric. That was, as I point out, there's a lot going on, right? So we have about 13 minutes left before 3. So Eric, if you want to stay here, I'm going to go ahead and start asking the questions that were pre-submitted. So we'll kind of, both you and Mike, Eric can chime in on these questions. Again, that is the beauty of asking your questions ahead of time, is that we have a little bit more time to get some really good information for y'all. So that's something that you can do while registering. I do want to also, while I'm getting these pulled up here, point out that we will have another webinar next month. It's going to be on leases. It'll be a CLE credited one for 1.5, hopefully. CLE credits is what we'll apply for. And so kind of a overview of common lease issues and how leases, the new laws that went into effect at the beginning of the year, impact leases going forward. So I'm going to put the link, the registration link to that for the March 20th Zoom webinar. All right, let's go ahead and get started here. So first off, so Anne is a service provider, and she just said, I'm interested in what is being proposed for housing choice voucher renter protections. I know you went into that a bit, Eric. So do you have anything else you want to add to that, or?
Yeah, just I'll just throw in the chat that bill. So that was the source of income protections that I just mentioned. There's a large coalition of which Homeline's a part of that's working on legislation that would address protections for tenants that have housing choice vouchers and other types of rental subsidies.
All right, perfect. All right, Tina is asking, I believe that Tina is a landlord, but Tina is asking, as a privately owned multifamily subsidized housing, can we use PHA guidelines for starting a resident council? And so obviously there's a lot of stuff built into that background ways, but do you have any quick responses to that, either Eric or Mike?
Yeah, and I'll throw this in the chat really quick too. Not knowing exactly who this landlord is or what type of housing it is, there is some resource on a federal level. The National Low Income Housing Coalition has a guide about renter organizing rights. If this person, if it is privately owned HUD subsidized multifamily housing, it's probably covered by 24 CFR 245. Which is outlined in what I just threw in the chat there. And then, as I mentioned, one of the bills that we just talked about in one of the last slides would expand right to organize to tenants in other types of housing. Right now, it's basically just on a federal level with public housing and certain types of HUD subsidized housing.
Fabulous. All right. Joe, who I believe is a tenant, is asking, why doesn't Minnesota legislation include a statement requiring prorated rent for the first month of the lease as well? So for a little context, there is a statute that requires prorated rent for the last month of the lease.
Right, and I just posted that in the link and in the chat, I'm sorry. And that's true. It only applies to the last month's rent. 504B.116 does that if the last month is prorated. A different statute, 146. I'm sorry, if the first month is prorated, it has to be clear in the lease. But it's not required that the law has to be, that the rent has to be prorated in the first month of the rent as compared to the last month of the rent. It is a gap in the law as it was written. This law was written a few years ago. Our office had almost nothing to do with the creation of it. I think this was perhaps a student orchestrated law that happens a lot, actually. Not a lot, but it happens some of the time, where university students or college students will work on legislation and they can get something passed, even at a time when the legislature was not all run by Democrats. And so that's when that bill was passed, and it doesn't address that first month question.
All right. Matthew, who I believe is a service provider, wants to know, have there been any discussions at the policymaker level regarding facilitating greater access to Section 8 vouchers for clients? So not necessarily, accepting Section 8 vouchers, but just giving more access to it.
Yeah, so facilitating greater access to Section 8 vouchers. Section 8 is a federal program through HUD, and so the numbers of vouchers that go out to participants in Minnesota and the housing authorities that serve them is determined kind of on a federal level, I believe. But there is an effort on a state level to enact a state voucher, rent voucher program, the Bring It Home campaign. And so in the chat is a link to the Bring It Home campaign.
All right. Thank you. All right. So then, all right, Jasmine is a tenant. And their question, I think, is more about breaking of lease reasons. And so in general, Jasmine, if you've got a specific situation going on here, I would definitely recommend calling us about your specific issues. It's why we're here, to help out. So if you've got, looks like mold or relocation, yeah, if you've got more details, feel free to give us a call at our number, which Mike will post to everyone in a second. And then, but yeah, I think that's going to be a good one to give us a call about, Jasmine. Samantha is wondering, so what Samantha's saying is that we need to change how critical it is to find a place to call home when having a background felons have a hard time. Similarly, Ronald had a very similar question, so I'm going to kind of combine them. Does the new law help and or impact the second chances for ex-offenders? And how can this new law support ex-offenders?
Yeah, so we mentioned the fair chance access to housing, Senate File 4015, Senator Mohammed's bill. And oops, I gotta change it to everyone. There's a link to that in the chat. Again, we're supportive of that. That's one way of addressing it. There's probably a lot of ways to address this issue, and there have been efforts in the past to try to work on regulating tenant screening in a more. I'll also just note that in the absence of the state doing anything in this area for years, Minneapolis did enact something in 2019. And there's a link to the local ordinance in Minneapolis that regulates screening and specifically regarding some criminal background aspects.
Fabulous. Thank you, Eric. All right, we're going to chug right along here because we've got a bunch of things in only about 5 minutes. I will say, Eric, I'm going to have to give you over hosting privileges here in about 5 minutes. So be prepared for that. And I think then, Mike, you're going to be on the hot seat for all of these. So let's get through this. Peggy is a tenant. So they have a question about late fees specifically. Their rent is due on the first and there's no grace period. Can a landlord just charge late fees starting on the second?
And the short answer is probably yes. The law that I just posted in the chat is the late fees statute in Minnesota, and it says that a landlord can't charge more than 8% of what the tenant owes for a late fee, but it has to be in the lease. It has to state in the lease when the late fee will kick in, how much it is. And there's no law that says that the landlord has to give a more substantial grace period, like the 5th, which is probably the most common late fee trigger date that we see. We also see the 3rd and the 7th, but the rent's due on the 1st and the late fee kicks in on the 2nd. That's legal.
Yep. All right. Short and sweet. All right. L is wondering if there will be a new state law that requires the reason for lease non-renewal and adjudication steps like 90 days before non-renewal is permitted.
To some extent, the retaliation statute that we proposed would do that. Also, the just cause statute that's been proposed as well would also address that. So yes, that's possibly going to be better if the laws change. Yeah.
Yep. All right. Judy, who is a looks like a developer for landlord building, multi-family housing buildings. How do you negotiate cheaper rent amounts? And some places didn't raise rents as high as expected, others did not. So, how does one negotiate? Any quick, like one or two sentence tips, I guess?
Yeah, I wasn't exactly sure who was asking this question. I didn't know if it was a landlord or if it was a tenant trying to figure it out,
I,
because landlords don't tend to try to negotiate cheaper rent amounts. So
yeah,
I thought
I'll
it was
admit,
yeah.
I Googled the organization that Judy put on
Oh,
their
okay.
registration, and that's how I got the developer. But maybe this is from a tenant perspective. I'm
Right,
not
right.
certain.
Well, yeah, I think it is from a tenant perspective. So if a tenant doesn't like the rent increase that's proposed by a landlord, a tenant can try to negotiate. In general, landlords don't want tenants to move out. Turnover is something that they don't want. They lose money on turnover. And so if the tenant says, well, if this is the rent, I'm going to have to move out, I'm going to give you my notice, or instead of the $1,200 you're raising my rent to from 1,100, I'll give you 1,150. It can be negotiated. Sometimes it works. I think the more information the tenant has, the more armed they are to make that negotiation work. Hey, I've looked around. There's some other places that look just as nice and are a little bit less, but here's what I'm willing to pay in order to not have to move. So there you go.
Yeah. All right. Leah, who is a service provider, is wondering when a tenant has turned in a request for fixing certain things, how long does it take for the landlord to, and it was cut off, but I think it means follow up.
Yeah. So it depends. If it's an emergency, then the landlord gets 24 hours to fix it before the tenant can take some action. So what's an emergency? No heat, no running water, no hot water, no working sanitary facilities, which probably means a toilet, no electricity. We've added recently, as of January 1, no working refrigerator, no air conditioner or elevator if those are promised as part of the deal. A serious infestation if the place has been condemned, or a notice of intent to condemn. Those are the emergency ones. Everything else, it's kind of a 14-day rule. The tenant can complain about it and ask for things to be repaired. They could go to a city inspector, might set up a different deadline, but it's probably going to be 14 days or 24 hours for most rental repair situations.
Mhm.
And Eric, I think you should take over. Rachel, you had to take off, right? That's what you said?
Yep, I was going
Hit
to
three
finish up
o'clock.
this last
Okay.
question.
All right.
And then I figured out that would be a good transition point. Sonma is a service provider as well, and wondering if there are resources that we could share that for tenants who are being bullied into paying expenses that they believe belong to the landlords.
Yeah, I think what this is about is a landlord's trying to say, hey, tenant, you got to pay for some repairs that we think you caused the damage on. I think that's what this question is about. And there is a rule in Minnesota on that a landlord can ask a tenant to pay for needed repairs if the damage was caused by the tenant either willfully, maliciously, or irresponsibly are what's required. And without one of those three things, then the landlord can't make the tenant pay for it.
All right, fabulous. Thank you, Mike. Thank you, Eric. Thank you all for coming. These two will stay on. It is 3:01, so I'm going to step off here. If you're able to stick around and answer more questions, again, this recording will be up on the website in a couple of days or within a couple of days. So I'm going to take off here. But Eric, if you want to share screen or continue on, have fun. We'll let y'all get on with yourselves. So bye.
Thanks, Rachel. All right. So we have 10 questions. We'll do the lightning round if we'll try to do a lightning round here, Mike. All right. Michelle says, I'm seeing huge collections amounts on the credit report, which is a barrier to acquiring new lease. Landlords are now avoiding eviction courts by adding collection amounts to the credit report. Funding does not help when when a landlord states its damages or move-out costs. How do I, as a HUD counselor, help people get housed with this new tactic?
So yeah, we get this question somewhat regularly, where a landlord has turned something over to collections or threatened to do so. There are a couple things. First of all, if the tenant had a security deposit, and they didn't get that deposit back, and they don't think they owe the money that the landlord is trying to collect from them, they could sue in small claims court for the security deposit to be returned. This isn't something that I'd want to tell a tenant to do sort of generically. I'd want to talk them through it, and talk about the details of their situation, because if they're going to just lose that conciliation court case, they're actually going to be in worse shape if they go that route. But if they believe the landlord owes them money, they could try a conciliation court approach. It's pretty low cost to get a neutral third party to listen to what's going on. If they owe the money, if the tenant actually owes the money, it's really difficult to just get that somehow eliminated. Although one can try to negotiate with the collection agencies. Now, you might not think that that works, but it really does. Collection agencies are in the business of collecting money. They don't really want to chase people. So if the tenant has the ability to save up money for a little bit and maybe offer half of what they owe, but all at once, the collection agency might wipe out the entire debt in exchange for that payment at that time. But again, very case specific. We'd want the tenant to talk to our office about that to figure out what makes the most sense.
All right, thanks, Mike.
Mhm.
Is Homeline working to change the language of the word landlord over to property manager or property owner due to the background of the word landlord?
I've also heard housing provider
Yeah.
might be the most common one.
So there's a Minnesota statutory definition of landlord. I just threw that link in the chat. I know that there's been some efforts by folks in the rental housing industry to try to change the term. It's not necessarily a priority of Homelines. We're focused on issues that are impacting our clients. Um,
So the short
so
answer is Homeline is not working on that. Right?
I think so, yeah.
Yeah. I mean, property manager, property owner, landlord. I mean, as Larry said, it is defined in the statute, so that's why we use the word that we use.
All right, anonymous question. My landlord has gone through my neighbor to have her call me to tell me the landlord is in the commons and wants me to come down to talk. Would this be a violation of my privacy? I went down and listened to her talking about my eviction and being homeless. My neighbors could hear it. Privacy violation.
Yeah, I don't know of any specific law that is being violated by this. It's bad business, I think, for the landlord to want to talk about things like that in a more public space. But as far as some sort of law being violated, I'm not sure that there is one that is being violated. Like I said, I think as a tenant, I would encourage the landlord, hey, you know what? I'd rather not talk about this in the hallway. Happy to talk about this in my apartment or back in your office if that's possible, if you'd prefer that space. Yeah, but as far as a law against it, I don't think so.
Anonymous question, are there any resources for owners within HOAs, homeowner associations, as in where complaints can be directed?
I'm sorry, I really don't have any great agencies to send you to that I know about that do this kind of thing. It's something of a serious gap in trying to figure out where somebody in an HOA can go to get help, but it's not anything we have any expertise in.
Yeah, so there's a state bar legal attorney referral search service that you can try. I'm not sure if this is the best link, but I'm going to throw it in the chat. I think that'll get you there. Okay. Is there an easy way to share links to folks in my organization so they can write to their legislators in support of House File 3? I would suggest we don't have anything like quick and easy here, and I don't have the slides up, apologies, but there in the chat is Michael Dahl, our public policy director's email. Also, this link that Rachel shared at the beginning of the session is kind of a brief overview of what is in the bill. Also has Michael's contact info. Really, it's as simple as making a phone call or an email to your legislator and mentioning the bill and why it's important to you. But if you would like advice or any assistance, reach out to Michael and he might be able to help. And then somebody also said, what was the first link for the 2024 proposals? So the link I just shared is kind of an overview, but then I will also put the specific House and Senate file numbers in a link in just a moment. While Mike is answering this next one, we are seeing more and more administration and or lease administration fees of up to $125. Are there any laws regulating these extra admin fees and how much they can be?
There's a brand new law, in fact, that has just come online as of January 1. And it says that a landlord can't charge a fee unless it's disclosed not only in the lease, but also disclosed in all advertising where the landlord is trying to convince a tenant to rent a place. And so there's no law against the fee, but they have to disclose it really obviously, glaringly. They have to put on the front page of the lease total monthly rent and also disclose the fees in all advertising. What I've seen from landlord lawyers, I'm an attorney that works just on behalf of tenants, but what we've seen from landlord attorneys is they're advising their clients to discontinue using fees and just call things rent, which is what it used to be before the fee era that we're in right now. And so the hope is that 504B.120 will stop the age of the fees from landlords.
Okay, and will you please speak to the expansion of the definition of residential building? Why have you included nursing homes and other healthcare providers?
Right. So somebody clearly clicked on the link to everything that we proposed, and it's in one of the first parts of this whole bill. Again, a very comprehensive analysis of landlord-tenant law as it sits right now and what it could be. Arguably, a lot of the things that this specific question is asking about are already covered by landlord-tenant laws, just not specifically obvious from the statutes. And this is trying to clarify in many of these situations what we think is already the case. And so that's why the expansion is happening.
All right. And then I think maybe one of the service providers said no, he's decided after the fact. I don't know if that.
Yeah, I don't know how to answer that one. There is another question though in the chat that came
Yeah.
up.
So this is a tenant who moved out because they felt unsafe at the end of their lease. The landlord isn't giving me a deposit back, trying to nickel and dime me for damages I didn't do, left the apartment in better shape than when I moved in. And they keep coming up with excuses as to why they're not going to give it back. Is there an email or anything we can use to reach out to one of you specifically? So I just in the chat, sorry, I've been putting a lot of stuff in the chat, and we will try, just a heads up, we're going to post a video recording, the slides, and we'll try to have some of these resources and links on our website on that recording page as well. But I just, before Mike put that statute in, I did put our hotline number, which is 612-728-5767. If you call, please leave a message. We can't get back to you unless you leave a message. Alternatively, you can use our email and attorney form. Either way works. And so I'll pass it over to Mike.
Yeah. And could you email us directly? Yes, but I know what my schedule looks like for the next 3 days. So if you emailed me directly, you'd get an answer in many more days than if you emailed our free email and attorney service. So I'd recommend that you do that. There's some intake questions that are asked up front that we ask pretty much everybody that asks us for help. It's a free service though, and it's going to be an attorney answering those email and attorney questions. But as far as your question, yeah, I mean, you might have a chance to go after the landlord in small claims court to try to get back the deposit. If you contacted us, we try to weigh the pros and cons of each option that you have and help you figure out, an informed decision on whether you want to pursue your landlord for that or not. It's up to you. But we'll walk through it, and it's a really individual thing. There's not one glib answer I can give you that would apply to everybody.
All right. We've accomplished it in only 10 minutes over. So
Yeah.
there's 37 attendees who got extra credit for sticking around. So thank you for joining us. Thanks, Mike, for going through the overview of this clarification, modernization, and equity bill for tenants. Again, we'll post the recording and some of the materials on our website within the next day or so. I just put a link in the chat for our Homeline Connection newsletter. I mentioned that earlier as a source for information about upcoming webinars. Rachel mentioned we do have some coming up in the next couple months here.
March 20th is the lease one, I believe she said.
Yeah. Yep. So you'll get, if you sign up, you'll get an email in early March about with updates about our legislation, and then info about that next webinar. So thanks again for joining us, and maybe we'll see you next month. Thanks all. Bye.